Effective July 1st, 2012, all common interest communities in the Commonwealth of Virginia were required to adopt an association complaint procedure. This video has been created to help anyone that wishes to submit a complaint through the association complaint procedure or better understand the process and determine if his or her concerns are appropriate for the complaint procedure. This video is for educational purposes only and does not constitute nor is it intended to provide legal advice. A common interest community is defined in the Code of Virginia as real estate located within the Commonwealth, subject to a declaration, which contains lots, at least some of which are residential or occupied for recreational purposes, and common areas to which a person, by virtue of his ownership of a lot, is a member of an association and is obligated to pay assessments provided for in a declaration. Sounds like a lot of legalese, doesn't it? In plain English, a common interest community, or CIC, can be a property owners association, often referred to as an HOA or homeowners association, a condominium association, or a cooperative association. If you are not certain if you live in one of these communities, you may need to consult with other owners in your neighborhood or with an attorney. The association complaint process is for any situation where you believe your association may be in violation of common interest community law. Common interest community law includes the Condominium Act if you are living in a condominium, the Property Owners Association Act if you are living in a property owners association or a homeowners association, and the Virginia Real Estate Cooperative Act if you are living in a co-op. Complaint procedure is not intended to address possible violations of your governing documents, meaning your declaration, covenants, bylaws, or any rules and regulations. Those are generally legal issues and are outside the scope of the complaint process. People have commented that it seems odd to submit a complaint to your association when your association is the subject of the complaint. While this is a valid question, the complaint procedure actually makes a lot of sense. First and foremost, you are sharing your concerns with your association, and if the association is doing something that is in violation of the law, it has the opportunity to correct the violation and learn from the process. Remember, the board of directors is made up of volunteers, and they may not always fully understand the laws that apply to association. On the other hand, if you learn your association actually is in compliance with the law, or that you simply misunderstood what the association is doing, the complaint procedure provides the perfect opportunity for you to learn more about common interest community law and to better understand why your association may have taken a particular action or made a particular decision. Submitting a complaint is usually straightforward. If you do not already have a copy of your association's complaint procedure, you will need to request it from your board of directors or from your association manager. Keep in mind that just because you have never heard about the complaint procedure does not mean your association does not have one. There is no requirement in the law that the association notify you of the existence of the complaint procedure. The association is, however, required to include it in disclosure packets and resale certificates. Your association complaint process should consist of an actual procedure explaining how to submit your complaint, to whom you should submit it, what documents are necessary, and what happens if you do not submit all the necessary information. Make sure you follow the complaint procedure precisely. If you want the association to provide a response to your complaint, you must ensure you have followed the procedure. For example, if your complaint procedure requires you to mail your complaint by certified mail, handing the complaint to a board member after a meeting is not proper, and the association could choose not to respond to your complaint. Once the association has received your complaint, it should provide you acknowledgement of receipt of that complaint within 7 days. This can be by hand delivery, letter, or email. If acknowledgement of receipt is by letter, it should be certified or registered. If acknowledgement of receipt is by email, the sender must retain proof of delivery. Once your complaint has been received by the association, the next step will be to provide consideration of your complaint, as long as the complaint is complete and submitted in accordance with the association complaint process and pertains to a violation of common interest community laws or regulations. Consideration is the process where the association reviews and makes a decision on your complaint. The association is required to provide you notice of the time, date, and location of consideration, and they must do so by hand delivery, mail, registered or certified, or by email with sufficient proof of delivery. The notice must be given within a reasonable time prior to consideration but the regulations do not require a specific number of days' notice. In some cases, an association may provide notice of consideration of your complaint, along with acknowledgement of receipt of the complaint. Others may provide notice of consideration at a later date. Consideration should usually be held in an open meeting unless there is a valid reason to hold it in executive session. The reasons for entering executive session can be found in the Property Owners Association Act and in the Condominium Act. Associations approach consideration in different ways. Some associations view consideration as an opportunity for an owner to explain his or her complaint and respond to questions the association may have about the complaint. Other associations simply have the complainant present while the board or other committee discusses and reviews the complaint. Once the association has considered your complaint and come to a final decision on the complaint, which may or may not take place at the same time, it must notify you of its final determination within 7 days. Delivery of the final determination can be done by, guess what? Hand, certified or registered mail, or email with proof of delivery. The final determination must include the date it was issued, the registration number of the association, and the name and license number of the Common Interest Community Manager, if appropriate. The final determination must also include the right of a complainant to file a notice of final adverse decision with the Office of the Common Interest Community Ombudsman and should include the proper contact information for our office. Once you have received your final determination from the association, there is nothing further to do if you are satisfied with the outcome of your complaint. If you are not satisfied with the outcome of the complaint or disagree with the association's findings, you have the option of filing a notice of final adverse decision with the Office of the Common Interest Community Ombudsman. In order to file a notice of final adverse decision, you must first obtain the proper form, which can be found on our website. If you do not use the required form, your submission cannot be reviewed and will not be considered complete. The form itself requires your name, address, and contact information, the name, address, and contact information for the association, and the date of the final decision from the association. In addition to the form, you must also submit a copy of the complaint you submitted to the association, including any attachments or documents, the final adverse decision from the association, reference to the laws and regulations the final adverse decision may have violated, and a copy of the association's complaint procedure. Finally, you must submit a $25 filing fee along with your notice of final adverse decision. The final adverse decision should be submitted to the address found on the Notice of Final Adverse Decision form. The Notice of Final Adverse Decision must be filed with the Office of the Common Interest Community Ombudsman within 30 days of the date of the final adverse decision. This means it must be received by this office within 30 days of the date on the final determination you receive from the association. This 30-day deadline is determined by the law and not by our office, so there is no wiggle room available, and we cannot, under any circumstances, extend it. Make certain that when you receive your final adverse decision from the association, that you make note of the date on the letter, not the date you actually receive it. You also need to make certain that your submission of a notice of final adverse decision is received by this office within 30 days of the date of the final adverse decision from the association. If it is received on the 31st day or any day thereafter, we cannot accept it. We encourage people to provide at least a few additional days before the deadline so that the notice of final adverse decision can be reviewed and you can be given notice if it is not complete. An incomplete notice of final adverse decision is not considered filed with us, even if you have sent it before the deadline. The notice of final adverse decision must be complete and the filing fee must be paid before it can be considered filed. If the cost of filing a notice of final adverse decision would cause you undue financial hardship, you have the option of filing a waiver of filing fee form. If you file this form, you have two options. You can file the form along with your notice of final adverse decision, and your notice of final adverse decision will only be reviewed after your request for waiver is approved. But approval of a request for waiver is never guaranteed. Or you can submit the $25 filing fee, your waiver of filing fee form, and your notice of final adverse decision at the same time. Your notice of final adverse decision will be reviewed if it has been properly submitted, and if the waiver of the fee is granted, your $25 filing fee will be refunded to you. Once your notice of final adverse decision has been received, the Office of the Common Interest Community Ombudsman will send you acknowledgement of receipt of the notice of final adverse decision, and will also send a copy of the notice of final adverse decision to your association so that they will know it has been submitted. After reviewing the Notice of Final Adverse Decision, which may take some time, if the Common Interest Community Ombudsman finds that the association's final determination may be in conflict with the laws or regulations governing common interest communities, the Ombudsman will provide notice of such conflict to the association and ask the association to come into compliance with the applicable common interest community law or regulations. If the association does not come into compliance after a reasonable time period, the matter will be referred for investigation and possible enforcement.